All right, so we're on the record in docket 24-02291. That is People of the State of Michigan versus Dustin Shaw. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson, people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Shaw.
And this is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. Received word from the court staff late yesterday that Mr. Shaw was in Calhoun County Jail at the time. Obviously, there's not enough time for a writ there. So we'd be requesting a good cause adjournment. Well, actually, I think he's already waived his 21 days, so I don't think we even need that. But nevertheless, we're going to need an adjournment. I believe at least 2 weeks to try to get him here.
All right, and that's a fair statement, Ms. Robinson.
Yes, I just found out as well.
Yeah. All right, so the defendant is in Calhoun County. He previously waived his 21-day rule on August 22nd, 2024. I just think we found out yesterday that he's in Calhoun County. So we will adjourn with enough time to get a writ to Calhoun County. And adjourn till when for the writ and the prelim. So we'll adjourn to October 11th at 1:30. And then we'll do the writ for Calhoun County.
If we find out he's somewhere else,
let us know.
We'll let everybody know.
Let us know where he is. Anything else for the record in 24-02291, Ms. Wilson?
Not for the people.
Ms. Robinson.
No, Your Honor, thank you.
All right, you should be all set on that file. And
Mr. Lavoy
is on his
now.
way.
No, he's off. Yep. He's over here. We can't see him.
Right.
You can come stand over here, Mr. Lavoy.
All right. So we're on the record in dockets. I'm gonna indicate them all: 22-03409, 23-00387, 23-03530, 2 accompanying tickets, and then the 24-02037. That's People of the State of Michigan versus Christopher Lavoy. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Lavoy.
And sir, you are Christopher Lavoy, is that correct? All right, thank you. This is the time set for a preliminary examination on this. Well, as a matter of fact, this is the time set for a competency hearing. And if I remember correctly, there are 2 felony files that we're going forward on. Ms. Robinson was appointed as a standby counsel on those 2 files. And then we have several other minor infractions, misdemeanor infractions. If memory serves me correctly, we started the preliminary examinations in regards to 2 felony files. And then when we came back, the Mr. Lavoy petitioned for mental health to be evaluated at the Center for Forensic Evaluation. I believe that Ms. Robinson helped in that endeavor of the petition. So we are set for 9:30 today for competency. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. Just for clarity, I believe there are 3 felony files.
Okay.
We started on 2 of them, the 223 files. The 24 file we had not started on, and I don't believe Ms. Robinson has been officially removed from that file yet.
All right, so we're here on 387 is one of the files, and then 3530.
And those are the 2 that we started on, and then we have 24-02037, which is a possession and a UDAA.
Okay, so that's 6-8. Let me make sure we have all the files.
So there should be in total 1, 2, 3, 4, 5, 6.
I'm not sure I have all, but I want to make sure we include. Here we go. All right. So we have 23-00387 is one of the ones, and then 3530 is the other one. those are the ones we started the prelim on.
Yes.
And then we have a 2402-037. That is the third felony you're talking about.
That is correct, yes.
And then we have the rest are misdemeanor matters.
That's correct.
34609, and then the 2 accompanying tickets.
That's correct.
All right. Thank you. That kind of sorts out
Yes.
the files.
And then in regards to the competency today, I am in receipt of the competency report. I believe Ms. Robinson is in receipt. I'm not sure if Mr. LaVoy has been shared it on the files that he is representing himself on. So I would leave that to Ms. Robinson.
We've reviewed it.
Okay. As far as the contents of the report go, it's not necessarily in line with the person that I've seen in the courtroom. However, I'm not a psychologist, so I don't really have a basis here to contest it. So at this point, I will be stipulating to the contents.
All right. Ms. Robinson, any comment, or do you want to make a record concerning it? It's my understanding that based on the report and the evaluation, the defendant was found incompetent to stand trial but restorable, which means that there's a certain amount of time the law provides for which to make Mr. LaVoy or to respond to Mr. LaVoy, the evaluation to make him restorable. I think it's 18 months.
15, I believe.
15,
Yeah.
all right. That's my understanding of the report. Ms. Robinson, any record you'd like to make?
We're stipulating to the report at this time.
Okay, all right. So I have a finding and order of competency on 23-00387. I'm going to sign that one. And I'll put today's date on that. And then did you do an order for each one?
I did for the 223 files. because
All right.
that's what we
Those were the ones that were in
chose.
front of us.
Those were the ones that
All
we
right.
packed.
So then I'm also going to sign on 23-03530 based on the stipulation of counsel to the report. And that's for 9/27/2024. And then we have, I think with the other files, we'll just, are they placed under the order?
Yes.
Okay, so we'll just place, and I'll make notes of that. We'll place all 3 files, so the pending felony file and the 3 misdemeanors on the 2 files. Let's go ahead and set a date, just so we keep track of the files, or else you know my feeling on that. I just don't want this to get lost. And I want community mental health to be working on the case if need be. So we will set report. And we will set for hearing, I'm thinking about 60 days.
Oh,
What did you say?
I said 90.
Yeah, it's 60 to, I think that's
Yeah.
fair.
Mhm.
I think 60 to 90 is fair, just to not lose track of
Yeah.
any of the files. So,
December 5th at 8:30.
okay, December 5th at 8:30. And set for December 5th on the 2 felony files in front of this court at 8:30 on December 5th.
3 felony files, running.
Yeah, but we only started on 2, right?
Oh, okay, I see what you're
Yeah.
saying. Yep,
Yeah, we only started on 2, and then the 3rd one, I think, came a little later.
it did, Your Honor. It was picked up while Mr. LaVoy was out on bond, and then it
Right.
was set in front of Judge Ward, and then it was transferred here.
So the petition that initially is done on the 2 files,
Yeah.
and then the other ones are following.
Well, I filed a petition on the,
Oh, on the other
On the
one?
third one,
yeah.
Okay.
So
On
there is filed on all the
240203.
files, yes.
all right, that, we don't have, that was a separate petition packet.
I did not see that. I'm not doubting Ms. Robinson. I'm just
Right.
wondering if it didn't.
If that order, if that number is on the order, then I'll just make notes accordingly, because I don't have an order to that effect in that file, but I'm not doubting that that file could have been forwarded along. I don't have it right now. Regardless, we're going to set it.
Ms. Robinson,
Yes, ma'am.
on the 24 case, I don't show that the clerk's office received your petition.
I should have. I filed it all at the same time.
I will follow up with them.
All right.
off the record.
Okay.
But we've set, so we will add that to the, and I'll make out, we'll do an order and we'll sign the order in regards to that, because that's the same evaluation,
That's correct.
but we'll just make sure that that's December 5th at 8:30. And then I'll do the notes accordingly. So I should see everybody back on these files on December 5th at 8:30. In the meantime, we'll wait for any evaluation to come, future evaluation in regards to restoring competency. Anything else for the record in docket 2303-409, 2300-387, the accompanying last felony of 2402-037, or either of the accompanying tickets, Ms. Wilson,
Not the people.
Ms. Robinson.
So it looks like the order for the 2037, the one that you're missing it on, actually was sent to Judge Ward. So.
All right,
Okay.
that's,
yeah.
so let us grab that from Judge Ward.
Yeah, it's just not showing it
Yeah.
anywhere. Yeah, I'll follow up with her.
But
judicial.
we'll follow up and make sure that we get it and it's part of this order. So it's all a part of the December 5th package. So thank you, Ms. Robinson.
No problem.
That allows us to follow it up. Anything else from the defendant, Ms. Robinson?
No, Your Honor.
All right, Mr. Lavoy, we should see you on December 5th, okay? All right. Thank you for your appearance today. You're all set.
Do I need to grab anyone else while I'm done?
What are we doing on Murray? Or not Murray?
None. He's
None.
gonna waive.
Wanna waive? All right,
He'll take it.
then none, please.
Yeah, we'll do
I
none.
do not have that file from the clerk's office yet, so let me see.
Oh, that's right.
That
He has another file that he's getting arranged on.
Who?
None.
What is?
Yeah,
The
it looks like it
53rd.
was sent to
The
Judge
offer
Ward.
is still the same, and then we'll just dismiss that one.
Okay.
Sure you insert it.
Oh, okay. So he's gonna get arraigned today on that?
Yes.
Or by Flores, or you want?
Yes.
So I have the none file, but then we have a separate arraignment file.
Yes, that is correct.
But
yes.
we can do that and then
And
grab,
then, yeah,
yeah, I mean, we can do that. We
And
just
it's
have
a
to get the
DD
file.
third?
yes.
Right, because of course we're gonna have to do the probable cause talks for exam.
I checked with Joe for his leave available.
Also ask
If-
to come
if
for,
not,
Schroeder on.
got other stuff.
Okay.
I only was asked yesterday. I have no contact.
You know where to find it.
Okay.
I'm expecting him to be here.
This would-
Yeah, I mean,
Stipulated.
she had okay contact with him.
So, right now.
So I don't know if she previously told him about today, but
I mean, when did, I mean,
it got set like this week, so.
yeah, I don't, know. she
Yeah.
didn't know that she's been out, she knows she's out, she's not even here, so.
Okay, so he might not know about it.
Yeah, he might
Yeah.
not know, but we're
What?
stipulating.
No, okay.
I was gonna say something, but I don't think that matters.
Okay.
We had another adjournment, didn't we? That,
Yes, he's here.
who's Mr. Rock?
Judge, I'm standing in for Mr. Rockeye.
All right, Mr. Ackley's in custody, so we'll bring him up.
I just went and talked to him.
All right,
Yep, thank you, Judge.
that was the 2 o'clock that we're moving up, right?
Milks is Cheeks here. Mario Morgan? No, you wanna go? Yeah.
Mr.
Anthony Cheeks.
Mr. Milks, how are you?
I'm doing well. How about you?
Pretty good. Now that I worked through all this, hair color thing that
Oh, yes,
I-
the true pressing matter.
That
of
was,
this
you know,
course.
Still,
Yeah.
I think we need to put him
I don't-
on the stand
Yeah,
today,
I don't,
Judge.
I don't think
feel-
so.
I
I
feel
don't-
like
I don't
I'm
think
being,
so.
I just don't want to know the truth on that.
I feel like I'm not getting
like a little
candor
mystery,
from
yeah.
from my brother counsel
Yeah,
here.
I like the gray in that.
Yeah.
The gray area, I should say.
Going lighter does help hide it a bit longer.
Yeah.
So, yeah, we're on the record in docket 24-02-662. That is people of the state of Michigan versus Anthony Cheeks. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Milks.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Cheeks. Mr. Cheeks is present and staying to my right at this time.
And sir, you are Anthony Cheeks, is that correct? All right, thank you. This is the time set for a preliminary examination in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The complaining witness in this matter did not appear today. She did inform my advocate yesterday that she did not want to appear, so I'm not surprised by her non-appearance. Without her participation, people cannot sustain their burden. I expect a motion from the defense.
Mr. Milks.
Thank you, Your Honor. Your Honor, at this time, if the people are not prepared to proceed, the defense is, this being the preliminary examination, we would request dismissal.
And the complaining witness was subpoenaed for today, is that correct?
That's correct.
So would you be so kind to hand me that?
Yes.
All right, thank you. Based on the, on defense counsel's motion to dismiss without prejudice, that'll be granted by the court. So Mr. Cheeks, which this means is the people could reissue if they choose to, but for all realistic purposes, the case is dismissed, all right? All right, I will sign the order of acquittal of Nolly Pross for 24-02-662 accordingly. Anything else for the record in 24-02-662, Ms. Wilson?
Not for the people.
Mr. Milks?
We were just wondering if the court would be kind enough to send a message or an email to JSG. I see heads nodding, so I appreciate it, Your Honor.
Yes, we'll email, and that's on the tether, I think.
Yes, Your Honor.
All right, we'll email to make sure that you'll have to go and get the tether removed. It takes about a day. It really does. It takes to just get that all purged out of the system. So if you go this afternoon, I think you'll be fine. But it takes about a day just to purge it, just to protect yourself, okay?
And that's referring to the no contact.
Yes,
Yeah,
yeah, the no
yeah,
contact,
yeah.
all the condition, the pretrial conditions, it takes about a day to purge that from the computer system.
Mhm.
We'll email GPS so that you can go and get the tether removed, all right?
Thank you.
All right, that's all for the record in 24-02-662. Thank you, everybody, for your appearance.
Thanks, Your Honor.
Thank you.
Thank you.
Yes. We were adjourned. Yeah, okay. Are you ready?
On
Are
Anthony?
you covering that one?
Yeah, I
I
am.
think he's here, yeah.
Yeah, he's here, he's outside. I'll be right
Okay,
back.
Maurice Anthony, that's just gonna be another adjournment. Yeah. Yes, please.
Right, so we're on the record in docket 24-02-068. That is people of the state of Michigan versus Maurice Anthony. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the Attorney of Record Aaron Schroeder with the defendant who is present to my right.
And sir, you are Maurice Anthony, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. In discussion with Ms. Schroeder prior to today's date, since she was going to be gone, we were planning on adjourning this. I believe there's been a 21-day waiver.
I don't believe so.
No, okay, then I believe we're gonna need a 21-day waiver.
Right, there's, I think we had the defendant was in custody and we left on for preliminary examination. And then we adjourned for good cause for surgery. It appears that there was some type of medical condition. And then we adjourned for discovery, adjourned for good cause for outstanding discovery issue.
Mhm.
If there's still an outstanding, and I know this is not your case, Ms. Donnelly, so I know you're covering today. But I do think that a waiver of the 21-day rule probably is in order in order to adjourn again today.
And regarding the discovery, Ms. Schroeder has it. She had just gotten it like that day of the prelim, and
All
it's
right.
like 100 pages of police reports. So
I
she has it.
I remember her saying that she had it, but it was
Yeah,
was
so
voluminous.
the discovery issue should be remedied.
Ms. Donnelly, is that a fair statement? And have you spoken to Mr. Anthony about waiving the 21-day rule?
It is a fair statement. I have spoken to Mr. Anthony about waiving a 21-day timeline.
All right, so may I inquire, Mr. Anthony, of the waiver of the 21-day rule?
Yes,
All right, Mr. Anthony, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Preliminary examination, as you know, is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You were represented by Aaron Schroeder. Today, you're represented by attorney Sarah Donnelly. They would be present to cross-examine any witnesses, contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination within that 21-day period. We've adjourned it for good cause a couple of times because of some medical conditions, but it is your wish to waive your right to a prelim within 21 days, have Ms. Schroeder back on the case so that she can zealously advocate for your defense. Is it your wish today to waive your right to a prelim within the 21-day period, not to waive your right to a prelim in general, just within that 21-day period?
For my information, I thought I already did my 21 days
We
last time.
I have that we've adjourned on 2 previous occasions for good cause, which means that you did not. We adjourned it, but so today I'm making sure that it's okay to waive it and to set it so Ms. Schroeder can look through all the evidence and make sure that she's all prepared for preliminary examination.
Okay, yeah.
Is it your wish today to waive your right to a prelim only within the 21-day period? You wouldn't be waiving your right to a prelim in general.
Yes.
Okay. Do the people also waive their right to a prelim within 21 days?
We do, Your Honor. Thank you.
Okay, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. We will reset for preliminary examination,
October 11th at 1:30, please.
October 11th at 1:30.
I got court October 11th.
oh, what time?
Yeah, what time do you have it?
It's at same time. It's like
It's in the afternoon.
Where is it?
It's at Livingston County.
Let's get another date. Yeah, because I don't want that. I don't want to be in conflict with another court date.
Yeah. Thank you.
October 17th
October 17th
at 8.
at 8:30. So, Mr. Anthony, you'll get notice from my court officer concerning that October 17th at 8:30 date, and then we'll reset for preliminary examination on that date. Anything else for the record in 24-02-068, Ms. Wilson?
Not for the people.
Ms. Donald?
Not for defense.
All right, Mr. Anthony, we'll see you on October 17th. Thank you for your appearance.
You're gonna get a notice here.
Mr. Nunn?
Yeah, 1:07.
I'll tell him that he's got what he's got.
Are they open now? What is those? I know Mr. I saw Mr. Armstrong said it. So I'm not entirely sure. You are, I will text you once I know.
Are you all set, Ms. Donnelly?
Yes, Your Honor, I am.
All right, and then we'll explain the other file because I don't have the other file right now.
Okay.
So We tried to do it and it's just
Gotcha.
too busy a day. All right, so we're on the record in docket 2402-462. That is people of the state of Michigan versus Ricardo Nunn. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Donnelly,
Assistant Public Defender Sarah Donnelly on behalf of the defendant who is present to my right.
and sir, you are Ricardo Nunn, is that correct?
Yes, sir.
All right, thank you. This is the time set for pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that the
Prelim.
defendant.
I say pretrial, it's prelim.
Prelim. It's my understanding that the defendant is going to unconditionally waive his right to a preliminary exam. The people also unconditionally waive their right. The defendant is waiving with an added count 3 of witness interference. And the PAT code on that is 750.1227A. And that's a 4-year and/or $5,000.
All right.
And the offer open to pretrial and circuit court is to plead to the witness interference charge that was just added and a DV second on this file. And then there is a possession charge out of 55th that my understanding is intends to waive to circuit court. As circuit court on that file, he can plead to a use as part of a package deal here.
All right.
And then as a part of the package deal as well, we would dismiss the new DV file once he's pled on the other ones.
All right. So there is a new DV file and we'll talk about that, but that's a part of these negotiations.
That is, yes.
Is that your understanding of the plea offer at this time, Ms. Donnelly?
Yes, Your Honor.
All right. May I inquire of your client of the waiver of the preliminary examination today?
Yes.
Mr. Nunn, you understand that you have the right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed the crime.
Yes, sir.
You are represented today by Attorney Sarah Donnelly, and she would be present to cross-examine any witnesses, contest any charges brought against you by the people of the state of Michigan. You understand that?
Yes, sir.
It's my understanding it is your wish to waive your right to a preliminary examination, have this case go on to circuit court under the terms that have already been placed on the record. So there's an offer and they're adding a count. And then we'll talk about wrapping all this up in circuit court. They're including a new file that you've not been arraigned on, and we'll discuss that later. All right, sir?
Yes, sir.
All right. Is it your wish today to waive your right to a preliminary examination based on the offer that's been placed on the record and move this to circuit court? Will the case will continue?
Yes, sir.
All right. And the people are also waiving their right to preliminary examination.
We are, Your Honor. Thank you.
All right. I'm going to have I have the documentation bind over, and I will present that to the parties for signature.
My goodness. I apologize, Your Honor. I signed in the wrong spot.
All right. All right, I'm in possession of the bind over documentation. It's signed by all the parties. Just so it's not a surprise, Mr. Nunn, we were attempting to arraign you on the new file that's part of the negotiation process, and we were not able to do so. So they should arraign you on that new file sometime within the next, I would think, couple days. That they'll go and write him over. It'll go through the arraignment process. I just can't get the file here for whatever
Okay.
reason.
All right, I understand, Your Honor.
Yeah,
Thank you.
but that file has already been accounted for in the resolution.
Is there any way perhaps Magistrate Milmore can see him today?
Yeah, maybe.
Okay.
Or if you would allow me a moment to hop off the bench, I can go see if I can find it out myself.
Yeah, do you have anything else that's, because we can go and see if we can get the file.
I would prefer to move the document
Yeah,
along
that's-
considering
yeah.
the size of
So,
it.
yeah, let's
So if Magistrate Milmore is available today,
Yeah,
that'd be
we'll see who's
fantastic.
available.
Yeah.
You've got to be arraigned on that. We were gonna try to wrap it all up today, but we've got at least 10, 15 cases on the docket. So, all right, but it is accounted for as a part of the resolution. Anything else in regards to this file before I sign the bind over documentation? Ms. Wilson,
Not for the people.
Ms. Donnelly,
Yes, Your Honor, we'd like to address bond.
all right.
Thank you. Mr. Nunn, as stated here, has one case out in 55th with Judge Allen that also has a bond on it that is holding him. In this case, he has a 5,000 10% bond that he needs to post. I think it's $250,000 based on the fact that this was alleged to have been committed while he was on bond in that case. So at this time, Mr. Nunn knows that he doesn't have, he still has to remain incarcerated until he can deal with Judge Allen. But the intention obviously now today is to waive these up to the circuit court and take an offer where hopefully the intention is that he serves probation. So with that, Your Honor, Mr. Nunn reports that he has a place to go. He has a job lined up. It was a job that he was supposed to start before he got incarcerated, but he has made contacts and they've assured him that he can still have that job. It's at U-Haul. So with that, Your Honor, we would just be requesting if at all possible to reduce the bond in this case.
All right, thank you, Ms. Donnelly. Ms. Wilson, any comment on the modification of bond request?
Yes, Your Honor. I believe Mr. Nunn's bond on his 55th file is 25,000 cash surety, which is rather high, as the court is aware. Frankly, I think if we're going to change bond today on this file, it should be increased. He just added a count of witness interference. I don't see how releasing him when he's not complying with the bond conditions while he's in jail is appropriate here.
All right. I do have that at the probable cause conference, Judge Buchanan reduced bond from a 7,500 10% to a 5,000 10%. I'm going to deny the bond modification based on the outstanding case, and then picking up the new case, that this is, this can be readdressed at circuit court, but I'm going to deny any bond modification at this time. All right, anything else for the record before I sign the bind over in regards to 2402-462, Ms. Donnelly?
No, Your Honor.
All right, I will sign the bind over to that effect, 27/2024. So, Mr. Nunn, your time in district court is done. You're now on to circuit court for the next court that'll review the file, and then you will get arraigned on the new file. Probably, I would think, if not this afternoon, probably by Monday or Tuesday, in order to negotiate all this. Okay. All right. That's all for the record. Thank you for your appearance today, sir.
Anybody else?
Mr. Sarts, are you ready on Carson?
Yes.
Carson, please.
I was also supposed to help Schroeder with
I'll see what I can do.
competency on Wrangle.
Yeah, I'll see what I can do.
On Niles Wrangle.
Yes, I was asked yesterday. I haven't been able to get a hold of him. I didn't know if he knew about this court date,
I'm just gonna go release a witness real quick.
All right.
but
Is he?
stipulating.
Yeah,
I believe she has good contact with him. It's just that she's been out of the office the last few days and didn't know about this date, I guess, and hasn't had a chance to reach out.
She sent me an email that she was reaching out to Mr. Cornish and Mr. Johnson.
Yeah, that's probably when I got wrangled into it.
Well, let's see what Miss Wilson's. I don't have a problem adjourning it concerning this. I'm assuming Mr. Wrangle's not here at this.
I don't think so. I haven't seen him. I have a
But-
picture of him. I don't see any
Right.
really resemble him.
Well, let's bring up after we get Mr. Sarts' client, let's go ahead and bring up Mr. Ackley.
Johnson.
Yeah, I'm not sure.
Brugnoli. Joseph Brugnoli looks like an attorney. Mr. Brugnoli, what case are you here on?
Good morning, Judge. I have Mr. Mark Johnson, and I spoke with the prosecutor yesterday via email, and we were just gonna leave it set for the prelim. She
All
has,
right, that was set. All right, so Miss Wilson's gonna be here in just a second. She's dealing with some witnesses. And then and Mr. Johnson's here via Zoom. So let's put that on the record, probably while we're waiting for the next defendant, Mr. Carson, to be brought up. So once Miss Wilson gets here, we'll put that on the record. All right, sir?
appreciate that. I do have another case in Allegan by Zoom at right now, so as soon as you can, that would be great. Thank you.
Just let us know. I mean, if you've got to go, you got to go.
That's fine. Thank
To
you.
the other case. All right. So let's see, is Mr. Brignoli, are you ready to go on Mr. Okay, you ready? So we're on the record in docket 2402-688. That is People of the State of Michigan versus Mark Johnson. Will the parties please introduce themselves to the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Brignoli.
Joe Brugnoli appearing on behalf of Mr. Mark Johnson, Your Honor.
And sir, you are Mark Johnson, is that correct?
Yes, Your Honor.
Okay, and you can hear me all right, Mr. Johnson?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. I believe this is already set for an exam next week. I think we're just gonna leave this on for now.
And that's a fair statement, Mr. Brignoli?
Accurate, Your Honor.
So we'll leave on for preliminary examination next week. That'll be on October 3rd at 1:30. So Mr. Johnson, please keep in contact with Mr. Brignoli. That'll be live in person on the 6th floor of City Hall of Lansing on October 3rd, 2024 at 1:30. Anything else in regards to the probable cause conference, Ms. Wilson?
Half of the people.
Mr. Brignoli.
Your Honor, thank you.
All right, Mr. Johnson, we'll see you next week. I believe that's next Thursday at 1:30. Thank you for your appearance today.
Thank you, Judge.
Okay. Is that home? Okay. Let me just check. Mr. Abbott? Chat with you real quick.
No.
That is people of the state of Michigan versus Marvin Phillips. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Phillips. He stands present to my right.
And sir, you are Marvin Phillips, is that correct?
Yes, sir.
All right, thank you. This is the time set for preliminary examination. I should indicate for the court that I had the opportunity to speak with counsel concerning this matter in chambers to discuss some of the implications of this case. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. There was a conversation. Initially, it was my understanding Mr. Phillips was intending to accept our offer with that conversation. I did release my complaining witness based on that information, as she did need to go to the doctor. She had a pretty nasty limp. It's now my understanding Mr. Phillips wishes to reject it, so I'm requesting a reset.
All right, and I think counsel's already spoken about that. Is that a fair statement, Mr. Austin?
That is, Your Honor. Mr. Phillips had indicated to me after we had the COPS conference that he would wish to avail himself of the offer. And moments ago, he told me that he considered it some more and he wishes to now reject that offer and proceed with this preliminary hearing. But I understand it based upon what he initially said, the complaining witness was released. So it would appear that we would need a new date for the preliminary.
All right, the arraignment was on August 29th. And I adjourned it last time for good cause. I don't have a problem adjourning it for good cause, but if we're gonna have a prelim, we now know we're gonna have a prelim on that day.
Mhm.
All right,
And I will note that this is a district offer only.
all right. So we will indicate that it'll be adjourned for good cause once again, but it'll be set for prelim and the prelim will go. Should we donate, about how long do you think prelim?
It's a one witness.
It's a one
prelim.
witness, so
October 11th at 9:30.
we'll set it for October 11th at 9:30. All right, Mr. Phillips, you'll get Mr. Austin will get the notice and give you the notice because my court officer is busy. We'll get you'll get notice from Mr. Austin. We'll provide you with what's been printed off, and I'll see you on October 11th at 9:30 for prelim. All right, sir?
Yes, sir. Thank you, sir.
Anything else for the record in docket 2402-521, Ms. Wilson?
Not for the people.
Mr. Austin?
Yes, sir. Just so nothing gets lost in translation, I want to make a record as to what the offer was.
Absolutely. Oh, absolutely. So you can indicate, make a record concerning the offer and anything else concerning this file, Mr. Austin.
Yes, Your Honor. My understanding that the people had offered Mr. Phillips this morning to plead, he could plead no contest to attempted CSC in the 4th degree, which would be a misdemeanor with non-public registry. We'd had a COPS discussion with the court regarding potential sentence. The court had indicated that the best the court could offer would be a 30-day cap, which would mean anywhere from 0 days up to 30 days in jail. And the court had indicated to counsel that the court would not have any objection to Mr. Phillips serving any jail sentence, should there be any, for work release, so that he could keep his employment.
Is that a fair statement, Ms. Wilson?
It is, Your Honor. Thank
All
you.
right.
And I did discuss it with the complaining witness prior to going on the record, and she indicated she was okay with it.
All right. So anything else for the record, Mr. Austin?
Yes, if I just may inquire, Mr. Phillips, is that your understanding as to what the offer was?
Yes, sir. I understand.
Okay. And you feel that you've had enough opportunity to think about that, consider that all?
I want to think about it more.
I can leave it open until the week of the exam, but after that, it's going away.
All right. So the exam is set for October 11th. So it'd be open till October 7th.
Yes.
So the offer extended is open to October 11th.
7th or 11th?
Seventh.
Seventh.
Did I say 11th?
Yeah.
The
Seventh.
prelim's the 11th.
The first time you
offers
said
open
the seventh and then the
Yeah.
second time the 11th, so I just wanted to make.
So
sure.
it's October 7th, that same week at the exam. That's the offer's open till October 7th.
Yes, in other words, Mr. Phillips would have to let me know by October 7th if he wishes to avail himself of that offer.
Absolutely.
Okay.
All right. Anything else for the record in 2402-521, Mr. Austin?
I have nothing additional on behalf of Mr. Phillips, Your Honor.
All
Thank you.
right, thank you. We're all set. Thank you for your appearance
Thank you.
today. And Mr. Etheridge, I think we're bringing up Mr. Murray
And I think we're gonna do a timeline waiver on Thomas.
on Mr.
before
All
then.
right. Thanks.
Yeah.
Do we know anything that's?
So. You didn't answer?
Yeah, you're,
Wait
here.
I think she just gave it to him.
Oh, okay.
Thank you. Meg, you approach real quick on another matter.
Absolutely.
I know, I'm just gonna be
Oh.
annoying like that.
The new
Um,
hair.
It-
Gives them a
Everything,
power trip.
everything is.
No.
Let me. Record in docket 2402-603. That is people of the state of Michigan versus Curtis Thomas. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Curtis Thomas, who is present to my right.
And sir, you are Curtis Thomas, is that correct? All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. There was an offer related in this matter for Mr. Thomas to plead to count two. That's the high BAC. Upon successful plea and sentencing, the balance of the complaint would be dismissed. It's my understanding he wishes to take some time to think about that. So we would be requesting an adjournment. I believe he's willing to wait his 21 days.
And is that a fair statement, Ms. Donnelly?
It is, Your Honor. We would prefer to have this set for a plea so that witnesses don't have to appear.
All right. May I inquire of your client of the waiver of the 21-day rule, Ms. Donnelly?
You may, Your Honor.
All right, Mr. Thomas, you understand that you have the right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Sarah Donnelly, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a prelim within 21 days. You wouldn't be waiving the right to a prelim in general, just within that 21-day period. So you'd have enough time to reconsider and consider the offer that's made in the case. Is it your wish today to waive your right to a prelim within 21 days? All right. And the people also waive the right to a prelim, obviously. Is that
We do, Your Honor.
correct?
Thank you.
I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will, we'll set this for plea, so you don't have to, but you'll let us know if we just need to put on for preliminary examination, then you can subpoena the witnesses.
Thank you. I
All right.
appreciate it.
But we'll set for plea for.
We're not doing witnesses. Can we do the plea next week or do we still need to?
How much time does the?
We have 2 weeks, Your Honor.
2 weeks.
2 o'clock on October.
October 11th at 2:00. So we'll set for plea for October 11th at 2:00. If this is going to be changed, and we'll move it to a preliminary examination date with witnesses, just let us know, okay?
Your Honor.
All right. Anything else for the record? 2402-603, Ms. Wilson.
Not for the people.
Ms. Dom.
No, Your Honor, thank you.
All right, Mr. Thomas, you're all set. Thank you for your appearance today.
Yeah, we'll get the notice of preview.
Mr. Etheridge here on Mr. Murray.
Yes.
And then how about Mr. Freeman on?
Was here, I'm guessing he's in a different court.
All right. So we can probably start on Mr. Cooper then. That would be the prelim, correct?
Yes.
And then if we need to take a break. All right, so we're on the record in docket 2402-677. That is People of the State of Michigan versus Jason Murray. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Etheridge.
Good morning, Your Honor. Attorney Derek Etheridge, also public defender on behalf of Mr. Murray. Mr. Murray is in the courtroom seated to my right.
And sir, you are Jason Murray, is that correct? All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant is going to unconditionally waive his right to a preliminary exam. People also unconditionally waive their right to a preliminary exam. There is no offer at this time. Negotiations would need to occur in circuit court. However, the people are recommending that any PA 53 violations that may be out there be dismissed as part of the waiver. I believe Detective Wilson submitted one yesterday, so I don't know if it's made its way.
All right. I'll place, so the offer's been placed on the record, and I'll put in that the offer for negotiations to continue and any PA 53 violation submitted would be dismissed. Is that a fair statement, Ms. Wilson?
That is correct.
And is that your understanding of Mr. Etheridge?
Yes, Your Honor.
All right. All right. May I inquire of your client of his waiver of the preliminary examination?
Yes, Your Honor.
All right. Mr. Murray, you understand you have the right to a preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented by Attorney Derek Etheridge today, and he would be present to cross-examine any witnesses, contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination today, have this case continue to circuit court where negotiations are going to continue. There's also a PA 53 violation that is not in front of the court, but is to be submitted, and that's going to be dismissed as part of this case. Is it your wish today to waive your right to a preliminary examination based on what's been placed on the record? All right. Ms. Wilson, do the people also waive their right to a preliminary examination?
We do, Your Honor. Thank you.
All right.
Can I have everyone just silence their phones now?
Yeah,
please?
sure.
Thank you.
I'm going to provide the bind over documentation to Mr. Etheridge. Thank you, Mr. Etheridge. I'm in possession of the bind over documentation on docket 2402-677. We indicate that the examination has been waived on today's date. Before signing the bind over documentation, anything else for the record in docket 2402-677, Ms. Wilson.
Yes, Your Honor, I'd like to address bond.
All right. You may address bond at this time.
Thank you, Your Honor. Mr. Murray's bond is currently set at 7,500, 10%. I am requesting that be modified to a 7,500 cash surety. And I am basing this off of, and I realized that there was an agreement to dismiss those PA 53 violations. They're not before the court right now. However, the content of those PA 53 violations is of great concern to the people. It has been shared with Mr. Etheridge, and I believe it's been shared by Mr. Etheridge through his client. There was a message that was attempted to deliver by Mr. Murray to the complaining witness in this matter on September 23rd. And oh wait, nope, this is the wrong one. September 22nd. Basically, the content of the message is that he hopes that she's sleeping with someone else so that he can kill them both. This is an assault that involves a dangerous weapon. It is a third offense of a domestic violence. I am very concerned that with the bond that way it currently is, we're looking at a potential homicide here based on Mr. Murray's statements.
All right.
I'm requesting that increase in the bond as well as a removal of his privileges for communications.
All right, with the victim.
I would prefer everybody except for his attorney. When we just remove it with the victim, what we're looking at is her creating a new account, and we're right back where we started. It really isn't doing anything.
All right, Mr. Etheridge.
Your Honor, regarding communications, we're asking the court to only allow the removal of contact or the ability to communicate only with the alleged victim. There's no allegation that they attempted to try to contact her through any type of third party. They can put in the phone number of the individual and email. If she changes her email address, that's nothing to do with him. That's her trying to make the contact, not him. So I'm asking the court to only take away any communication with the alleged victim. Regarding the bond, Your Honor, I would ask the court to leave the bond set as is. He's not even able to post the bond as it is set. There is a statement or a email that I was provided and talked to Mr. Murray about. I don't want to say whether or not, this is true or false or whatever. He was just frustrated and sent a message that well, I guess it's not true that he was going to attempt to hurt or kill anybody. He was just frustrated with his case and what was going on. He didn't mean it. She never received it. It was rejected by staff. So I would just ask the court to leave the bond as is set. You can't even post it as set. Thank you, Your Honor.
Thank you. Any response, Ms. Wilson?
Thank you, Your Honor. Whether it was said in frustration or not, murders happen in frustration, and I know I'm beating a dead horse and maybe sounding a little dramatic, but this is a domestic situation. These are highly volatile. These are rife for continuing issues. So I do think that increase in bond is appropriate. Regarding whether or not the communications can be removed just with the complaining witness in this matter, I reiterate that it's really, it doesn't do much. And I will also note that if Esther changes her email address, Mr. Murray still has to accept her request to communicate with him, which he's already done. So I don't think we have any good faith here that that's not going to happen.
All right, but Mr. Murray, you understand the no contact order is that even if you receive any, once you accept it, you provided contact. And so that's a violation of no contact order. That may be where the pending PA 53 came from. I'm going to reiterate, and this can be revisited in circuit court. I'm going to modify the bond to 7,500 cash surety. And then I'll reiterate that there's to be no contact, and that's direct or indirect, with the victim, Esther Jamalski. Which means that if Ms. Jamalski attempts to contact you, you have to bring it to the jails, bring it to anybody, but you start with the jail, indicate the victim's trying to contact you. I don't want anything to do with her. Once you indicate that you want to accept any type of communication with her, then it falls on you. It doesn't fall on Mr. Jamalski, which that's the nature of the no contact order. All right. So it's as much as your protection as is for her protection. If she's contacting with you, you're to have no contact with her. But that is the direct order, because I don't have any indication that we have indirect contact. But there's no contact, direct or indirect, with the Esther Jamalski, and then I'll let circuit court determine whether they want any further restriction of privileges would be available to you. I'm not ordering that you're not that the restriction. So I'm granting Mr. Etheridge's request that only apply to the complaining victim. If there's indirect contact with the complaining victim, then it just becomes an issue. Okay, and that's indirect contact means you could tell somebody else to contact her, and if that happens, then we got the same problem that we have right now. All right. So I'm going to modify the bond to 7,500 cash surety. There's continued no contact with Esther Jamalski. That's direct or indirect. 2,000 feet of her place of work, business, or place of employment, and we'll go from there. Anything else for the record in 2402-677, Ms. Wilson?
Not for the people.
All right, I will sign the bind over document because I forget to, and then they tell me I forgot to. I will send the bind over document. Mr. Etheridge, anything else for the record in 2402-677?
No, Your Honor, thank you.
All right. All right, that's all for the record in that file. Thank you, everybody, for your appearance.
Thank you, Your Honor.
Are we waiting on Morgan then?
Yes. What's up?
Yeah, let's go ahead. So we're kind of waiting on Morgan. Let's start Cooper, but let's take 5 beforehand so everybody can get all set up.
Thank you.
Because I don't know where Mr. Freeman might be in another hearing.
I'm assuming that's where he is.
So let's take 5 and then we'll come back and we'll start the pre.
All right.
Right, you can be seated.
Gotcha. All right.
I made a case.
Yeah.
And you can use mine was like.
Yeah. Yeah.
So,
Okay.
and I think he's.
Yeah, I'm gonna go talk to him.
Okay. Want me to go with you?
Yeah.
Yeah.
Sorry.
You can call.
I keep saying.
Or you can wait for.
We should have just.
The
switched
judges in
off.
here, just wait for your most comfortable.
If you don't mind staying just a bit longer in case maybe she don't show up, I don't know.
You're fine. I just wanted to double check.
I got 23 cases.
By like 10, right? Or
By now.
right now?
Yeah.
No, I was, I told you, like, for a while there.
I was
On a roll.
Oh, okay. Okay. I don't know why we know about this. I don't know. Okay.
all rise. Airport officer shaking.
Don't need anybody first.
The inmates are like, that's bad. How did they say? The one was scared.
Yeah, that's not, you can be seated. All right, so we're on the record in docket 24-02223. That's People of the State of Michigan versus Aaron Cooper. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. White.
Walter White, P 27792 on behalf of defendant, I am retained counsel.
All right, thank you. And sir, you are Aaron Cooper, is that correct?
Yes, that is.
All right, thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I do have my officer here. I'm ready to proceed.
All right. So is there anything to come to the court's attention before we get started on the prelim from the people?
General sequestration. I only have one witness here, so it shouldn't be an issue.
All right, Mr. White.
I have no witnesses for
All right.
preliminary exam purposes.
All right, so I'll leave it to counsel to let me know if anybody walks in that is a potential witness or maybe a witness later, but appears it's a one witness. But you'll know if you see it, you know your case better than I do. So with that understanding, Ms. Wilson, you may call your first witness.
Thank you, Your Honor. People call Officer Anthony Dean.
Right, Officer Dean, you can come up here and stand right in front of me, and please spell and state your first name and last name for the record.
Anthony Dean, ANTHONY, DEAN.
Please raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth on the penalty of perjury?
I do.
Right, have a seat, officer. The microphone is for recording purposes, so please project to the back of the courtroom as best you can. Ms. Wilson, you may, when you're ready.
Thank you, Your Honor. Officer Dean, where are you employed?
Lansing Police Department,
And what's your job title?
police officer.
What are your general duties?
Road patrol right now, go to calls for service, do traffic stops, things of that nature.
And were you working as a Lansing police officer on July 26th of 2024?
I was, yes.
What were you wearing during your shift?
My police uniform,
And does that have police designated somewhere on it?
it does, yes.
And where was that?
On the back of my vest, I believe it's on the front too, but I'm not 100%, but I know for sure it's in the back.
Okay. And were you driving on foot or something else?
I was driving a police vehicle, fully marked police vehicle.
And is that department issued?
Correct, yes.
Okay. And when you say fully marked, does it have police designated somewhere on it?
Yes.
And where is that?
On both sides of the vehicle, it says Lansing Police, and then on the back of the car, it says Lansing Police as well.
Okay. And is it equipped with emergency lights?
Correct, yes.
And are those department issued?
Yeah.
Okay.
Yes.
Now on that on that July 26th date, did you have occasion to conduct a traffic stop at or near South Cedar and East Miller?
I did, yes.
And is that in the city of Lansing?
It is, yes.
Ingham County?
Correct.
State of Michigan?
Yes.
And what was the basis of that stop?
I was stopping a subject that was speeding and failed to use their blinker when getting into the turn lane.
Okay. And how did you initiate that stop?
My steps, or?
Yes.
I got behind the vehicle, activated my lights on the patrol vehicle, and they stopped.
They did stop?
Yeah.
Okay. And did you make contact with the driver of that vehicle?
I did, yes.
And at some point during your interaction with him, did he provide you with his name?
He did, yes.
And what was that name?
Aaron Cooper.
And during your interaction with him, did you get a good look at him?
I did, yes.
Would you recognize him if you saw him today?
Yes.
Do you see him here in the courtroom?
Yes.
Would you point him out and describe something he's wearing?
The gentleman with the gray button up.
Thank you. Your Honor, I'd request that the witnesses identify the defendant.
Okay, and that's the person sitting next to the man, to the individual in the suit
Yes,
on the
sir.
left of him.
Yes, sir.
Any objection to the witness identifying the defendant for preliminary examination purposes, Mr. White?
No, I acknowledge that.
All right, but without objection, the witness identified the defendant. You may proceed.
Thank you, Your Honor. At some point in interaction with Mr. Cooper, did he advise you that he was in possession of a firearm?
He did, yes.
And did he have a license to carry a concealed pistol?
He did not.
Did he provide you with consent to search the car?
He did, yes.
And did you in fact search the car?
I did, yes.
Did you find a firearm?
I did, yes.
Where was it?
It was in his backpack and backseat.
Okay. And was it in anything inside the backpack?
It was in a soft case.
And are you familiar with firearm storage materials?
Correct, yes, I am.
Is based on your familiarity with that, was that something that was designed for the storage of a firearm?
Your Honor, I'm going to object to this. This requires a rather specialized knowledge, and I don't know that the officer can demonstrate that he has the specialized knowledge on whether a sock case is or is not designed for a firearm.
It's a 702 objection. It's a specialized knowledge response.
Your Honor, I can lay a little bit more foundation, but I will say he is an officer. He carries a firearm. He has familiarity with storage materials for firearms.
If you want to lay foundation, I'll sustain the objection. The officer can indicate that he's not doing it in the realm of any
It's not
type
an
of
expert.
expertise.
It's a lateness.
Yeah, so But I'll let you lay a little bit more foundation based on what is experience. I'll sustain the objections.
Thank you, Your Honor. How long have you been a police officer?
Around 8 years.
And in the course of your 8 years as an officer, have you handled firearms?
I have, yes.
And have you handled materials that store firearms?
Correct, yes.
And different kinds of materials?
Correct, yes.
Okay, Your Honor, I think that satisfies.
All right, you may proceed.
Thank you, Your Honor. Now, based on your recollection, do you know if that case that it was in was designed for the storage of a firearm?
Not for transport, just for safekeeping, I would say. It was a soft case, not a hard case. None of the transportation of firearms are in a hard case.
Okay, and was it?
Your Honor, I'm gonna make an objection now. The transportation in a hard case or soft case is a legal conclusion.
All right.
It's not part of the statute in the state.
All right, response, Ms. Wilson.
That's fine, Your Honor. Delay witness opinion. The court can give it the weight that it thinks it
All right,
deserves.
with that understanding, the objection is noted and you may proceed.
Thank you, Your Honor. Now, what kind of car was this in?
It was a Chevy Colorado.
Okay, and is that a pickup truck?
Correct, yes.
And-
Small size pickup truck.
And pickup trucks, they usually have a bed, is that correct?
Correct, yes.
And was this one covered or uncovered?
I believe it was the bed.
Yes.
I believe it was covered, yes.
Okay, and the firearm you said was in the back seat, is that correct?
Correct, yes.
Not the bed of the enclosed, or not the enclosed bed of the truck?
Correct, yes.
Okay. Was the firearm loaded or unloaded?
It was unloaded.
Okay, and was there any ammunition with it?
Yes.
Where was that?
Was inside of the small case, I believe.
Okay. I have nothing further, Your Honor.
All right, response and cross-examination, Mr. White.
Officer, when you approached the vehicle, Mr. Cooper identified himself
Correct, yes.
and he told you that there was a firearm in the vehicle.
Correct, yes.
And did he indicate that where he was coming from?
Yeah, he said he was coming from a firing range or gun range.
And the firearm that was in the vehicle, he told you where the backpack was, is that correct?
Correct, yes.
And it was on the right side of the back seat of the Colorado of the pickup, correct?
I just know it was in the backseat. I don't know if it was on the right or the left. I can't remember that.
All right, I don't have the whole video here. But I do have a picture I can show you and see if it refreshes your recollection. I'm gonna show it to council first so that I'm not getting all fancy on it. You take a look at that for a moment. Let's see. Does it refresh your recollection as to where you saw the case?
Yep.
Now,
So
case was on the far side of the back seat.
one question, what is your memory of where you saw the case based on the?
Based on that,
refreshing?
it was on the driver's side backseat.
Okay, thank you.
Excuse me. You looked at this, it doesn't appear to you to be on the passenger side?
No. If anything, maybe in the middle, but that viewpoint is from the driver's side of the vehicle.
Right, so this was a picture taken from the driver's side of the vehicle, so it would show the location of the.
All right.
The thing. I'll get to that, I guess.
Your Honor, if we just want to stick to admit that photo, I'm fine.
All right.
That's
you
what I'd
want-
like to do.
All right, so we'll skip to admit defense exhibit A. I'm gonna grab it here.
Hopefully you won't get all the ink that might.
All right, we'll go ahead and mark it.
Oh, all right.
So if you can bring it forward. And I'll have it marked and I'll admit it pursuant to stipulation.
Thank you, Officer.
Thank you,
Or,
Mr.
Your
Honor.
Honor.
Thank you. All right, so I'm in possession of this defense exhibit A. And we'll have it marked. It's a photograph. And pursuant to stipulation, I will admit defense exhibit A, which is a photograph. You may proceed, Mr. White.
All right, now, my client directed you that the firearm was in the case,
Yeah,
and so pursuant to his agreement, you looked in the case, the firearm was in a sock in the case?
not like a soft case, not a sock.
It was in a soft case. Did the case zip up?
Yeah,
Okay, so was it a soft case that would zip up? Was there any ammunition in the firearm?
no.
Is there any ammunition in the case?
Based off of my memory, maybe, but I'm not sure. I can't remember based off of my
Do you
memory.
remember where, okay, the firearm was unloaded.
Correct, yes. I do
You
remember
found-
the firearm.
You
was
found the ammunition.
correct
Where was the ammunition?
in the backpack with the gun.
But I'm saying, was it, you don't have the backpack here, do you?
Oh, I don't have the backpack here.
Okay. Was the ammunition in a separate pocket in the,
Yeah, like I said, based off of my memory, I can't remember. I would have to review my body camera or my report, but I bet I cannot remember. It's been
all right,
several months.
okay, so, and you said there was some marijuana in the case. I assume that was just somewhere in the backpack also.
Correct, yeah.
All right. Now, there was also a rifle in the vehicle, is that correct?
Correct, yeah.
Where was the rifle?
In the back seat.
Was it in a case?
Yeah, it was in a hard case.
And that rifle was an AR-15 type rifle,
Yeah,
and it had a suppressor, a silencer on it.
correct, yes.
Right, now, did you see paperwork showing you that the silencer was properly registered with the federal government and the $200 tax had been paid on it?
I did, yes.
All right, so the rifle and the silencer are not part of this charge, it's only the handgun.
Correct.
Yeah, I'm gonna object, the people charge the case, not the police.
I agree, she is correct.
All right, so that's a fair statement. So it's noted for the record.
I shouldn't object to you making legal statements and
Right.
then asking to make
Right.
the same thing. All right, so there was the firearm was unloaded in a case, in a zip-up case that you would store a firearm in, that was in a backpack, that was in the back seat of the truck, in the location shown. The location in the picture is an accurate representation of where the case was when you first saw it, correct?
No, because it was in the backpack.
No, maybe I'm
I
asking,
think that was probably a compound question.
it was a compound.
Yes, and it was
You
confusing.
saw the picture I showed you, the backpack in the back seat.
Correct, yes.
Is that where the backpack was when you
Yeah.
first saw
Yes,
it?
sir.
I'm not trying to get fancy on you. I'm trying not to get confused myself. Okay, so I don't have any more questions for your witness here.
All right, thank you. Ms. Wilson.
Briefly, Your Honor. Officer Dean, based on your memory from where the backpack was when you saw it, was that in a place that would be in reaching distance from the driver's seat?
Yes.
All right, nothing further.
All right, and people, a couple of questions that I have, Officer, on Defense Exhibit A, is that the, where you found the gun in that case?
Correct, yes,
In the
sir.
software,
Yeah.
I'm pointing to this, there's a soft case with a zipper, that was in the backpack.
Correct, yes, sir.
All right, and then you have no recollection, did you find the ammunition in the zipper case, the smaller case, or did you find it in the backpack itself? If you recall.
I don't recall. I would have to look at my body camera.
All right, thank you. Any comments or questions based on the court questions, Ms. Wilson?
No, Your Honor, thank you.
Mr. White?
No questions.
All right. May this witness be excused from the people, Ms. Wilson?
You may, Your Honor.
Yes.
May this witness be excused. All right, thank you. Thank you for your appearance today, sir.
Defense has no witnesses for purposes of preliminary examination.
So, Ms. Wilson, any further proofs?
No, Your Honor, thank you.
The people rest.
We do, Your Honor, thank you.
The defense has indicated that they don't have any witnesses today. That's correct, Mr. White?
That is correct.
All right. Motion for bind over, Ms. Wilson.
Yes, Your Honor, thank you. The defendant in this matter is charged with a single count of complaint, and that is a CCW, carrying a concealed weapon. This is based on carrying a concealed weapon within a motor vehicle. Here we have a lawful traffic stop where there wasn't a blinker used and the defendant was speeding. The defendant apprised the officer of the fact that he had a firearm. So clearly we have knowledge of a firearm in the vehicle. A firearm was subsequently located in the vehicle. And the condition in which the firearm was stored is really the issue here. And that is pursuant to NCL 750.3231A. And that requires that a pistol where there is not a concealed pistol license to be in a car where it is unloaded in a closed case designed for the storage of the firearm and in the trunk, or in a place not easily accessible if there is no trunk. Now, what we have here is a pistol that was unloaded. It was found in the backseat of the cab of a truck in a backpack in a smaller case. Now, whether or not we want to call a truck with a closed bed a trunk is really kind of an issue of semantics. Regardless, it was easily accessible from where it was in the car. Officer Dean testified that it was within easy reach. There were no locks on it, so you could have opened the bag, opened the subsequent bag, gotten the firearm. So it is easily accessible. It's the people's position that if it's a closed bed, it is in effect a trunk. So that's where it should have been anyway. Whether or not we want to get into whether the case was designed for the storage of a firearm, there's maybe some question as to that based on Officer Dean's testimony, but regardless, the firearm was not where it should have been. It was easily accessible. It was not carried in compliance with the statute. And I recognize that he was coming from a shooting range. That doesn't change the fact that it still needs to be stored correctly in the car when he's coming to and from. So I would request bind over.
I have one question.
Yes.
If the backpack and the soft case were in a trunk, would they be legal?
I think they would be, correct.
All right, Mr. White.
First off, Your Honor, and I realize that's a side issue. The back of a pickup truck, whether it's got a cover or not, is actually outside the truck, just like the hood or the trunk is. However, it is a place where you could store a firearm. In this particular case, though, the firearm was registered. My client immediately revealed its presence there when he was pulled over by the officer. It was in a separate case inside a briefcase or inside a backpack. There was no ammunition in the container with the firearm. And the only question is how readily available the backpack would have been and the case contained therein. I would argue that the defense to this charge would be that you can't demonstrate, or the people can't demonstrate that the firearm was that available, was that accessible based on the testimony of the guy. I would ask the court to deny a bind over and dismiss the charges.
Thank you. Well, I really, first of all, the standard for the court is probable cause. And as a probable cause determination, identifications are made. So the location, venue ID, and date have all been made by a probable cause level. So we have the elements of the offense, and it looks like this offense comes down to accessibility of the firearm in a truck that has an extra back seat. That seems to be the issue, is the accessibility of the firearm. And the firearm is in a case, in a backpack, in another backpack with unloaded with the ammunition. The officer indicates he doesn't remember where, but the ammunition was either in the backpack or separated, but the firearm was unloaded. So it's incumbent on this court to determine whether probable cause exists concerning this matter. And I think it's a close call. I really do. There's accessibility as to the firearm is based on the back seat. It's based on it being in a backpack that's zipped up with a soft, which appears to be for a firearm, a soft carrying case. I'm going to use that for lack of a better term. Inside the backpack in a vehicle that is a truck, but it's not a traditional truck, at least not one that I see, but they are traditional now. It has a back seat to it. And so the question is this accessibility in an indication? I think by the spirit of the statute that this is not an accessible firearm. I think the firearm is not loaded, it's in back. I think that if he was driving, it would not be accessible to unzip it. I will think, but by the letter of the law, one has to be real careful. I mean, and this is indication of how careful that one has to be concerning this matter. But I do not find there's probable cause to bind this case over to circuit court. And at this time, I'm going to dismiss count 1, the CCW, based on the accessibility of the firearm and the notion that it was coming from the firing range, which means it was intent to put it back there. But I don't look at it as a true CCW concealing because everything was done, and then you have the firearm placed in the back seat. There's also a tarp in the back seat that would not exactly make it completely accessible from the front seat, because there's a tarp in the front range, which means you'd have to reach over the tarp to unzip the weapon, to take the weapon out, to unzip the weapon, to take it out of the soft case. And I'm not sure that was a determination as a letter of the law, based on the facts, mostly based on the stipulated defense exhibit. I understand the nature of the case. I understand that this is not a traditional truck, but I'm going to dismiss the case at preliminary examination for probable cause. I do not find there's probable cause to believe that the defendant carried a dangerous weapon, to wit a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, a Chevrolet Colorado. I do not find probable cause to bind over, and therefore the case is, as long and under these facts, is dismissed. Anything else for the record in docket 24-02223, Ms. Wilson?
No, thank you, Your Honor.
Mr. White.
The only other thing is we would like to get the property back, in particular the rifle, because he's got a federal license.
Yeah, as long as the paperwork's in order, all evidence should be provided back to since there's not any type of charge. All evidence should be provided back to Mr. Cooper. That's probably going to take some time because it's in evidence. I'd probably seem to take a week or two.
And I believe one of the bond conditions is not to possess a firearm. So until that's cleared from Lee, they're not going to give it back.
And so it would take about a day to purge the bond conditions from the computer just to be safe. But you should be able to get the evidence back, any evidence confiscated within a week. All right.
Thank you very much.
Thank you, Mr. White. And I'll defense exhibit A, I'll provide back.
Thank you, Your Honor.
You're all set, sir. And then we have Mr. Freeman's case.
Yes, the last I saw, he was in Judge Buchanan on another case.
Finishing an argument.
All right.
Okay.
So I'm not going anywhere.
I don't think I am either. Honestly.
Yep.
I was this close.
You were close. It was wishful thinking on your part. And we've got that training of that, but so just let me know. Just let me know on that.
Thank you again, Your Honor.
All right, thank you. The
We're not muted, Judge, just so you know.
the docket 24-02-072. That is people of the state of Michigan versus Aaron Matula. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
And good morning, Your Honor, or good afternoon, Your Honor. Stephen Milks on behalf of Ms. Matula, who is present and standing to my right.
And ma'am, you are Aaron Matula, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
If I could.
Okay.
Sorry, Your Honor.
So you'd like to defer?
That's fine, yeah.
Sorry, thank you. Your Honor, the prosecutor's office has been negotiating in good faith and true and honest good faith here, Your Honor. We had everything set up for a plea today, potentially under 7694A. As my client and I were talking, I realized that she's got a previous misdemeanor assault conviction, which would preclude her from availing herself of the 7694A. We would like to set this for a plea hearing still. Prosecutor and I are going to go back, try to discuss. We anticipate that there will be some sort of resolution, but because the things have kind of fallen apart at this point, at least regarding our original plan, we will need a little bit more time for negotiation. But Your Honor, we do expect this to be resolved one way or another.
All right, and so, my understanding is that the defendant has previously waived her 21-day rule on August 2nd. Do you have any objection to the adjournment for future plea hearing and for renegotiation of Ms. Wilson?
No, Your Honor, Mr. Wilkes and I talked about this ahead of time, and I was aware that this was going to happen.
Okay, so let's set for plea date. About what's the time frame are we looking at?
I would say at least 2 weeks. It sounds like
weeks.
Mr. Milks also has some information he wants to gather to get to me ahead of that as well.
All right, so we'll set for extended plea hearing or adjourned plea hearing.
October 11th.
On October 11th. At 2 o'clock. All right, so based on representations of counsel, we'll adjourn the hearing to October 11th at 2 o'clock. You should get notice from my court officer, all right? Anything else for the record in 24-02-072, Ms. Wilson?
Talk to the people.
Mr. Milks.
Your Honor, my client does have a ways to travel. She lives in Calhoun County. I know the court isn't really keen on it, but if it would be okay if we end up going through with the plea in 2 weeks, if the court would be okay that she appear via Zoom and enter a plea that way.
I don't have a problem with pleading by Zoom. The problem is that getting her to probation. But she'll have to come in and go to probation. They'll have to set up a time. As long as the plea as long as that it's ensured that she gets to probation in person and does everything that they require, I don't have a problem with the plea by Zoom.
Okay, if that's okay with Your Honor, we'll do it that way. I can also coordinate with the probation department to see that we can make sure that's.
Ms. Wilson, do you have an objection to a plea by Zoom?
As long as I'm notified ahead of time, so I know whether or not I need to have witnesses or anything here, I have no problem with that.
All right, so we're gonna set it for plea, so there
Okay,
won't
then
be any
never mind.
indication
Then
of witnesses.
we're good.
So I'm gonna indicate that Zoom is appropriate by plea, and then this will be for plea. And then I'll wait for if anything changes, the parties can let me know, okay?
Thank you, Your Honor.
All right, anything else for the record in 24-02-072? We set for plea and Zoom is appropriate on that date at that 2 o'clock time. Anything else, Ms. Wilson?
No, Your Honor, thank you.
Mr. Milks?
Thank you, Your Honor, no.
All right, Ms. Matula, we'll see you on that October date. Thank you.
Okay, thank you.
And then on the next case, you're waiting for a witness?
Yes, it sounds like, I haven't seen her yet. My advocate tried to call her and didn't get a response, so I'm not sure. I think there was a subpoena issue, because it sounded like she didn't know that this was happening today. So I think Mr. Freeman's not gonna be here until 2, because he seemed to think that's when we were starting.
Right,
So,
I pretty much kind of
Yeah.
guarantee that we're gonna start at 2. All right, so when Mr. Freeman gets here, we'll go down and get the defendant, and then just let us know when you're
Yep,
ready.
all right, thank you. Did you finish your training?
I did.
Yeah, was it informative?
It was, it was, why?